Hello, everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. If you're enjoying our legal education content, please remember to subscribe. It helps the channel grow. For today's story, we're doing one inspired by the recent CrimeCon convention that happened in Austin, where, among other things, they talk about people who are wrongfully convicted and the difficulty of getting them out of jail. And this is potentially one such case. This is the case of Louis Villavicencio-Serna versus Latonia Jackson. In this case, Louis was convicted of committing a crime on somewhat dubious, dodgy evidence. The big problem being, however, that juries seemed to know all about the dubious, dodgy evidence and convicted him anyway. So the question is, for at least the federal court, what, if anything, can we do about it? So let's learn a little bit about this conviction, the dodginess therein, and the standards of review, and try to assess what we think about all this. Let's get started with this. Haruta was shot and killed in a parking lot of his apartment complex in Illinois in the early morning hours of May the 16th of 2009. Haruta had been drinking beer with his uncle that night. At around 3:30 in the morning, a car pulled up. An occupant fired 4 or 5 shots, and the car sped away. Although he was a little drunk, and I'm feeling that's a bit of an underestimation because, again, drinking beer with his uncle at 3:30 in the morning, but okay, the uncle over here was able to testify as to relevant details. The uncle told officers, first at the scene and later, that despite the darkness, he was able to see the passenger car and could tell it was a dark blue or dark green Honda. Okay, although the police officers had little evidence implicating anybody, officers turned to the protagonist of our tale, Villavicencio, after his girlfriend's father reported her missing that morning. This guy, whose 16-year-old girlfriend lived with his parents in the same apartment complex in which Haruta was shot. All right, so 2 incidents are happening roughly the same time, right? There is a shooting at 3:30 in the morning at this apartment complex. Meanwhile, there is a father. There's a father who's reporting that their 16-year-old daughter, the girlfriend of the guy we're talking about, is missing. So the police think to themselves, well, maybe these 2 things are related, which is not a wholly unreasonable thing to think. The 2 events are concurring roughly simultaneously, so not the worst investigation place to start, but, not so much because she came home later. So she came home from wherever, and the police, they went to 7 p.m. to resolve the missing person report. Okay. But the officers still had some concerns. The officers still thought maybe this was related. So the officers became suspicious that this girl's temporary disappearance was related to this shooting, and so began to question her, which, again, maybe it is, maybe it's not. This girl goes missing from this apartment complex. She's 16 years old. She's nowhere to be found. For several hours, it seems. Meanwhile, there's this shooting that is happening. So is her fact that she's disappeared somehow related to the shooting? Not the worst idea I've ever heard of in my life. It's contemporaneous, so we might want to ask some questions. But how we ask those questions is a little bit more concerning than the underlying idea of them being related. So the officer began by questioning this girl. The girl says that she doesn't know anything, but to her knowledge, the guy who's involved, Louis, who's the protagonist, was not involved. Unconvinced, the officers continued to press her. Some 8 hours later, at 3 in the morning, the officers began to record her tale. We have some trouble here. We have some questions in our mind, right? The police think that this girl might know more than she does, and maybe she does. And they're questioning her for 8 hours. And then 8 hours later, at 3 in the morning, when so many good decisions are being made, they only then start to record the conversation. So here's what happens next. The record captures her saying that she spent the night with Louis, the protagonist, on the night of the shooting. After falling asleep at 2 a.m., she woke up around 5 and observed that Louis was cold to the touch. He told her that he took care of business. In order to explain what business this might have been, Vasquez, the girl, told the police that Lewis didn't like this person, Huerta, because Huerta repeatedly contacted the girlfriend in the past, and just last week he called her at 5 a.m. So the girlfriend says the guy was jealous and killed her out of jealousy, or killed him out of jealousy, after 8 hours of questioning. Lewis told the girlfriend that he was prepared to shoot him or beat her, I guess. So the girlfriend is over here saying, after 8 hours, yeah, I went to sleep at 2 a.m, and then I woke up at 5, and he was cold to the touch. And he said it's because he took care of business, because of the jealousy. All right. We have some more. The officers were not finished with the girl. They brought her back for some more questioning a few hours later. This time she brought a radically different account of events. Oh, that's interesting. She has a different story to tell. Okay. Once again, though, the officers did not begin recording her immediately. The recording didn't begin for 4 hours. So much like the first questioning, a lot of this is kind of off the record. The girlfriend recounts that Lewis had answered the phone when the person who was killed called the girlfriend the week before and told him not to effing call my lady no more. So now she is saying that I had overheard this phone call from the week earlier. Referring to an offline conversation, the officers asked the girlfriend to repeat the news story, in which she said she was in the car the night of the shooting. Well, that's a pretty different detail, right? That's a bit of a different detail. We've moved from I was asleep at 2 a.m, and I woke up 3 hours later to find my significant other cold to the touch and saying he did the shooting. But now, wait a second. No, maybe I'm not asleep in bed. Maybe I'm in the car the whole time. Well, that's a bit different. Okay. In this version of the events, Lewis, the guy, called his friend to pick him up. This guy drove a silver Cadillac, which I'd like to remind you is quite a bit different than the dark green car we saw earlier, with their friend in the passenger seat, while the girlfriend sat behind them, and Lewis sat behind Rogers. They first drove to the girlfriend's apartment. Officers asked the girlfriend whether she pointed out this person when they arrived. She responded that she might have said something like, "Damn, I think that's the guy." She then stated that she drove through the parking lot twice before Lewis, our protagonist, leaned out the passenger side window and shot him. Our story has evolved rapidly. I was asleep. No, wait a second. I was in the car during the drive-by. Okay. Officers left the girl alone for less than half an hour, during which she was visibly distraught. So the officers, having conducted this second interview and not recording it for 4 hours and then doing this, they left her alone and she began being distraught. She's now throwing up in a McDonald's bag and is hunched over the seat crying. She also paced around the room and slammed the wall, saying that she was frustrated. This part apparently is videotaped. About 5 hours later, the girl told a substantially similar story, except this time, he said that Lewis reached over her to shoot Herrera. So it's not shooting out the window. It's now he's shooting across her. Okay. So then the police talked to this friend that they apparently picked up for this drive-by. Okay, so we're going to talk to the friend who the girl implicated as the driver. Initially, this random guy denied any involvement. However, after 6 hours of unrecorded questioning and an emotional breakdown, the cameras came on. The officers again referred to the unrecorded conversation, asking a random guy here to just pretty much explain what they covered before. So, prompted, random guy recounted that he was hanging out with Rogers when he received a call from the guy, Lewis, sometime after midnight, like 1, asking them to give the girl a ride home. They then drove around the parking lot twice and noticed the guy who would be shot speaking angrily. Lewis shouted at the guy 4 or 5 shots and urged him to take off. So, yeah, so no, I wasn't involved. Yes, I was involved. Okay, all the rest of that. So that seems questionable. Rogers' experience at the police station followed the same pattern. After repeatedly telling the officers he knew nothing about this, he changed his story too. Rogers recalled that the random friend received a call from Lewis at around 10 or 11, not after 1, mind you, asking the friend and himself, friend of a friend, to hang out. They drove around for a while, Lewis seated behind Rogers and the girl in the car. Eventually, Lewis asked to drive over to the apartment where they began yelling at each other, and then the guns were fired. So we've got many different sources. We've got many different stories from our witnesses here. All right, in this youthful shooting. We've got 3 different witnesses who all didn't tell the story the first time. And then a whole bunch of conversations happened off the record with the police. And then their stories are kind of changing and modifying about who did what and when and whom, and who was involved and who wasn't, and what time was it? Was it after 1? Was it 10 o'clock? Was it because we wanted to hang out with a friend, or was it because we wanted to drive someone home? We have many inconsistencies in these stories. Not all things are aligning well here weren't aligning well. So let's move on to the trial, because we're going to have a trial over this for some reason. Okay. So at trial, all 3 of the witnesses recanted their testimony. This is going super well for the prosecution, okay? So now we're prosecuting Lewis for the drive-by of Herrera, right? And we've got three witnesses: the girlfriend, the friend, and the friend of the friend. And we've called all 3 to the stand, and all 3 are now on the stand recanting their testimony. Okay? That's how well this trial is going. All right. They each insisted the officers used scare tactics to convince them to implicate Lewis, the protagonist, and to ratify the officer's version of events, a version that they said had been fed to them while the equipment was off. So the officers told us what to say, and then we just said it back. Vasquez, the girl, swore the officers provided every detail of the latter account. It was their story. I was just repeating it. The friend accused the officer of threatening to plaster his face around the city as a murder suspect unless they adopted the story they were pushing. And Rogers, friend of the friend, said the officers threatened to put him in jail as an accessory unless he also told the story. And then Rogers also said that he made the whole thing up. So we've got all 3 witnesses on the stand saying the officers pressured us, told us the story. We told them what they wanted to hear after much questioning. And yeah, and the jury heard all that. That's the critical detail in this thing. The jury heard all these things. They heard all these things. That's important, right? So let's press on. This was the evidence offered at trial. The jury then decided, how about guilty for first-degree murder? The jury thought proof beyond a reasonable doubt. The jury, apparently, in their infinite wisdom, did not see reasonable doubt in all of this. Because, again, the jury knew about all this. Okay? All right. As we've noted, after exhausting his state court remedies, Lewis unsuccessfully petitioned for a writ of habeas corpus from the federal court. The district court said no, but allowed him to appeal to see whether or not that would be great. So, all right. So, yeah, I don't even begin to know what to tell you here about this. Now, the jury is the finder of fact, and the jury can believe. I'll just give you the law. How about that? Let's just start with the law. The jury is the finder of fact. They can believe or disbelieve witnesses in whole or part, because witnesses can lie, and they can lie about lying, right? So the jury is the trier of fact. So they can believe that a person's lying, and if a person's lying, they can believe they're lying about the lying, and maybe it's really true. Or they can choose to believe any reasonable inferences that's available from the evidence. Right? That's what juries are for, to determine what is true. Now, it seems to me, your humble legal observer, looking at this from the outside, it seems to me that it's somewhat hard to come to the conclusion of proof beyond a reasonable doubt when I've got all three court witnesses on the stand telling me that they're liars. I don't know. I find that a little bit difficult to come to the conclusion that, yeah, proof beyond a reasonable doubt. But apparently 12 people over here had no problem coming to that conclusion. And how about guilty for first-degree murder? For the drive-by. Okay, so now we're going to try to appeal that, and we're going to try to see whether or not we need to set that aside. So let's do that now. Let's see whether or not we're going to set aside this guilty conviction. The Supreme Court has repeatedly emphasized the availability of federal habeas relief is limited with respect to claims adjudicated on state court proceedings. So this is very true. There is a role for the federal courts to play, but it is a limited role because, again, we live in a federalist system. And the states are sovereign and the federal government is sovereign. And so the federal government's role here is a little bit limited in terms of what they do on a habeas, right? We're on a collateral review. We're not on a direct review because all that's over now because the Court of Appeals of the state had no problem with any of this. Court of Appeals of the state is perfectly fine, so great. So now the federal court is in the position of looking at this very differently from their point of view. The relevant law, as you may know, is the Anti-Terrorism and Effective Death Penalty Act. We've talked about it before. It dictates that review of the state court's decision should be based on reasonableness alone. This is a stricter test than what would apply to a direct appeal. We're in a different posture than, this is not the same as if there had been a federal trial conviction and we're the Court of Appeal reviewing it, right? We're in a different posture. The Court of Appeal was the state court, all right? So that's different. So this is stricter than what we would do if we were the reviewing court on the proper appeal, but we're not, right? So instead, in a direct review, we would ask where the evidence taken in the light most favorable to the government and deferring can support the finding of guilt beyond a reasonable doubt. Okay? So if we were directly reviewing this, we would ask, is the evidence taken in the light most favorable to the verdict? Because, again, proof, innocent till proven guilty has happened. That's over now. And so now all of our things flip. And so we would say, okay, taking the evidence in the light most favorable, is the jury's verdict is it sustainable? That's the question we'd ask if we were the Court of Appeals directly, but we're not. Instead, on this standard, we can grant relief only if the evaluation by the Court of Appeals, which in this case is the State Court of Appeals, of their evaluation is objectively unreasonable. So this is two layers of deference, all right? So, if we were the Court of Appeals reviewing this on a direct appeal from a trial level, we would ask the question, is the evidence taken in the light most favorable to the government, does it support the conviction? But we're not that. So now we're asking even one more level beyond that. Did the court below reach an objectively unreasonable decision about that decision? Right? So it's not only did the government have enough evidence, but did the Court of Appeals render a decision that is not reasonable? It's very deferential. If it sounds deferential, it's supposed to be, because that's the federal standard under the federal law. Yeah, that's right. Lewis takes issue with the state appellate court's determination the evidence presented at trial was sufficient. You know, Lewis, I'm with you on this one. I also take issue with not only the state appellate court, but also the state trial court's determination the evidence is sufficient. I am somewhat inclined to feel like the jury could not come to the conclusion of proof beyond reasonable doubt in this circumstance. With no physical evidence of any kind, and 3 witnesses, all of whom have completely recounted, and yeah. So, if I were the Court of Appeals, That's what I'd be saying, but apparently I'm wrong because the Illinois Court of Appeals said exactly the opposite of that somehow. So, okay. The central focus of Lewis's petition is his contention no reasonable jury could have relied on the testimony of his three friends. Yeah. He adds that we've condemned tactics designed to exhaust suspects, including long interrogation, which might lead to being unreliable. Right? So that can be a problem. Here's a few aspects of this that make things even more problematic, right? Vasquez, the girl, is 16 years old at the time. Her interrogation ran 8 hours before she made any incriminating statements. And only 8 hours later, when she was presumably somewhat tired, officer brought her back for another 13 hours. Another 13 hours of interrogation, during which she gives a completely different account that was central to the conviction and led the officers to these other two people. Vasquez, the girl, having undergone this, how much is 13 plus 8 again? 21 hours of interrogation, exhibited some signs of distress. But this distress could be interpreted in two ways. Either frustration from the pressure of unwarranted accusations or from the stress of being peripherally involved. Yeah, I suppose her signs of stress could go a couple different ways. It could be that, she's frustrated from, the police, or that she's involved in a murder. Yeah, okay. The choice, however, between these two distinct possibilities is for the jury. The same is true for the emotional breakdown of the friend for his 8 hours of interrogation. So, yeah, because we have a question of fact, right? That sounds suspiciously like a question of fact. It is a question of fact. I'm so glad you noticed, right? Is her stress and her vomiting and all this, is it due to either A, because she's 16 years old and she was interrogated for 8 hours until 3 a.m. and then brought back for another 13 hours. So is it that she has been brainwashed into a statement that the police handed to her? Or is it because she's really telling the truth and she's frustrated at being peripherally involved in a murder? Well, that sounds suspiciously like a question of fact, which is what we have juries for. So let's ask the question. Let's ask the jury. Oh, apparently it's because she was frustrated at being involved in the murder. Okay, jury. All right. These aspects of interrogations are concerning. They're concerning to me too. It is troubling that the three witnesses later retracted their accounts. Yeah. The record does not reveal whether those recountings were coordinated or wholly independent. Not that I'm sure 100% matters, but whatever. However, as the federal court, the federal law standard here does not authorize us to revisit the jury's interpretation of events or decide whose testimony is credible. The witnesses all testified at trial. The jury is in the best position to decide whether to trust the recanting or whether to recount the original thing. So the jury got to observe all this. And it is not for the Court of Appeals, really in any instance, and certainly not on a double level of review, as we are here, to revisit the jury, who, in their infinite wisdom, apparently viewed these witnesses and said, yep, we're convinced beyond a reasonable doubt. We don't believe the recantation. We believe the original story, despite the complete lack of physical evidence. We disbelieve they're saying that they lied. We think proof beyond a reasonable doubt. That's the conclusion this jury apparently came to. Okay. Lewis's concerns about the tactics used during this interrogation are also overstated. Lewis is trying to get some mileage out of flaws of the collection of testimony other witnesses presented against him. But, and here's the big problem, the jury was aware of it. The jury knew. The jury knew all these things. They knew about the 8 hours. They knew about the 13 hours. They knew about the age. They knew about the different stories. So Lewis is over here saying, hey, the police used really, really coercive tactics. And the Court of Appeals is like, yeah, but the jury knew all that, and they're the trier of fact. And in their infinite wisdom, apparently they decided that Lewis over here was guilty the whole time. Okay, that's a thing that happened. There is more, but we need not belabor the point. There is nothing unusual about a jury hearing conflicting accounts and then resolving the best that it can. Nothing more sinister than that happened here. Okay. All right. The contradictions that appear in the record, we conclude, are not serious enough to compel a finding that the state court unreasonably concluded the jury verdict did not fail for lack of sufficiency. So basically, as the Federal Court of Appeals, the only way that we can undo this is if we can conclude the Court of Appeals was off of its rocker. And, you know, the Court of Appeals, I'm not sure the Court of Appeals was off its rocker necessarily. The trial judge maybe more so, but were it me as a Court of Appeals judge, I think given this fact pattern, I might be somewhat inclined to go the other way on this one, because this feels kind of thin. And also as the trial judge, I have to say, man, I couldn't say for sure, and I'm not saying that if I were the trial judge, I would have done it, because who knows what I would have done, but I'd at least be thinking about it. I'd at least be thinking about how about a directed verdict of not guilty, which is of course a thing, the trial court can do, right? The jury can come back guilty, and the trial court can say, how about not guilty? It's a directed verdict. And, I'm not saying I would have done it, but I'd be thinking about it. I'd be thinking, how about not guilty? Because this seems proof beyond a reasonable doubt. Really? You resolved all that, and in your heart of hearts came to the conclusion beyond a reasonable doubt based on this, he was guilty? I'm not necessarily saying I'm better than the 12 of you, but, not so sure about that one. But apparently the trial judge had no problem with it. And the Court of Appeals looked in like, okay, and then, that's where we're at. So, alrighty. The Illinois Court of Appeals methodically analyzed the record before concluding the evidence was sufficient to allow a reasonable jury to find guilt beyond a reasonable doubt of first-degree murder. It concluded the jury had ample opportunity to determine which of the stories was most reliable. The state further noticed the jury may have regarded some of the recantations as unreliable. For example, Rogers, the friend of a friend, testified that he could not have been in the car that night because he was with his girlfriend, but Rogers' girlfriend, so now we're of a girlfriend of a friend, testified they were not with her. The court added that the jury was entitled to credit the uncle's identification of the car, which I'd like to remind you, the uncle originally identified the car as a dark green Toyota, and it was in fact a silver Cadillac. But when the uncle went to the police station and said, was the dark green Toyota you saw this silver Cadillac, right? Because the police brought the uncle over. The uncle had said, I saw a dark green Toyota. And then they brought him over to the police station and they said, hey, is this silver Cadillac the dark green Toyota you saw? The uncle said, yep. And the jury said to themselves, yep, we see no problem with that. That seems perfectly fine. Those two things can be readily confused. Yep. When we said dark green Toyota, we meant silver Cadillac. That's the same thing. Juries, they're good. All right. And it could find motive from Lewis's invictive message on the phone the week before the murder about don't call my girlfriend. So, yeah. Okay. Oh, I apologize. I'm sorry to the chat. I'm so sorry. I said dark green Toyota. The chat has corrected me. I'm sorry. Dark green Honda. I think Toyotas and Hondas are relatively close, so hopefully you'll forgive the error on my part for saying Toyota when I meant Honda. But yes, you're correct. It was a dark green Honda. That definitely makes the difference because Hondas look more like Cadillacs than Toyotas or something. Let's press on before we think about that one too hard. None of these conclusions fall so far outside the boundaries of rational disagreement that we could brand it as unreasonable. Not every case has physical evidence that definitely resolves doubts. But that type of evidence is not required, which, sure. Yeah. Here, the state court concluded in its infinite wisdom, the testimonial evidence and circumstantial evidence met the constitutional standards. And Lewis has not given us enough reason to disturb that conclusion, so enjoy being in jail forever on the first-degree murder conviction with the complete lack of physical evidence and a dark green Honda that's really a silver Cadillac, and the multiple recantations and the multiple hours of interrogation, because, as I mentioned, many, many times the jury knew all those things, and apparently they said to themselves, well, those are, we're convinced beyond a reasonable doubt, so good to go. Let's move on before we get too much more depressed. Thus, that brings us to the end of the case, and it looks like it really is the end of the case. For Lewis Villavicencio-Serna versus LaToya Jackson. In this case, Lewis over here is convicted of a drive-by shooting in which the evidence against him is somewhat weaker than we might ideally like in a first-degree murder case. But the jury knew all these things. And the jury looked at all the evidence and they said, yep, proof beyond a reasonable doubt. We're convinced. So yeah. And the Court of Appeals for the Seventh Circuit comes to the right legal conclusion, probably, although I'm even questioning that a little bit, to be honest. But they, it's deference upon deference, and the Court of Appeals for Illinois did look at it methodically. They did look at it in detail. They considered everything, and like the trial court could have come to this conclusion somehow. The trial, okay. So that brings us to the end of the discussion of this case. Thank you so much for being part of the Uncivil Law family. If you enjoyed this legal education content, please hit the subscribe button. It really helps the channel grow. We appreciate your continuing support. Until later, my friends, cheers and goodbye. I don't know. This is yeah. I don't have a great deal of confidence, in my humble opinion. The jury came to the right conclusion. Now, I wasn't there. So maybe it's different. Or maybe not. But 12 of our peers. 12 of our peers have looked at this and been like, yeah, okay. And the trial judge apparently didn't want to go with the directed verdict thing. So yeah.